Okay, okay. Yeah, so we are actually trying to get the attention of the chairperson of Icon S Nigeria, Professor Wahab Ewewole, SAN. He just called me now that he's joining shortly, but it's nice that we are all here connecting. I have to be moderating with me today's program, the co-chairperson of the Nigerian chapter, Professor Ngozi Chumaume from the Imo State University and the Director of Academic Planning of that institution. On our bill today, we have very distinguished personnel who will be speaking to us. I want to recognize, in no particular order, our keynote speaker, Mr. Amar Ahmad. Ahmad is joining us from Calgary in Alberta, Canada, so it's quite early for him this morning. We have Professor Numan Rayad joining us from University of Leicester. We have Honorable Justice Fidelis Anyuku, um, who is joining us. He's a judge of the Anambra State High Court. Um, we also have Professor Margarita Salvadore, who is joining us from um, University of Torino. We have Dr. Akiola Akintayo. Dr. Akintayo is joining us uh, from the University of Lagos. We have Professor Olukayode Joshua Olatoke. He hasn't come on at this time. Professor Latoke is also joining us from the University of Ilorin. He's also built to be one of our co-speakers today. So just for us to kick off, Professor Wahab Ewewole SAN, the chairperson of the Nigerian chapter, is on. I will hand over to him to give us a few welcoming remarks and set the ball rolling for this event. Professor Wahab, you're welcome, sir.
Thank you so very much, Professor Azubike. I apologize that I had to join late. I was just leaving a meeting, and the issue that we have set for ourselves for discussion this afternoon, at least as far as Nigeria is concerned, is constitutional development in a globalizing era. There is no gainsaying the fact that this is topical, especially if we go back to what the world is witnessing today. And I'm saying this advisedly with effect from about 20th of January this year. The constitutional law development is thoroughly being challenged in the acclaimed world democracy. And as constitutional law students, practitioners, and researchers, I believe that this is one area we should focus our attention on. And in doing this, I believe we need to go beyond research in our and teaching our classrooms. We should be more impactful. And being more impactful is the kind of conversation that we are having this afternoon. We must also go beyond this to identify projects, identify countries, and come up. Yes, I know that there is a rule of law index that is together, but as ICON S, as constitutional law researchers, I think we must go beyond this approach and be and go to the society that we want, see how the citizens are feeling on constitutional law development. And if we look at what transpired in Africa a few months back, this has also given credence. But if what is happening in United States of America can happen, I believe what has happened in the African countries could well be sadly. But on the whole, let me hope that this our conversation will bring to fore issues that will positively affect democracy in our various countries, issues that will eventually have to also define Icon S as an organization. Once again, I say a big welcome to all of us and hope that we'll benefit maximally from this discourse. Thank you so very much.
Thank you, Professor Ohabe-Wewole. Thank you for that welcome. Professor Ngozi, please, may you proceed with the next actions.
Okay, thank you, Professor Zubike. And I want to say thank you once again to the chairperson of ICONX for those introductory remarks. And like for those of us that may be joining us for the first time, ICONX really, I want to give a brief overview of what ICONX is all about, especially the mission of ICONX and then the various chapters from the various regions and jurisdictions. ICONX, like we all know, is the International Society of Public Law. It is an association for the global community of public scholars, not just scholars, but also for judges and practitioners. And sometimes it might even, the ICONX family includes also a wide range of national and regional chapters, and sometimes include interest groups, interest groups that also engage with public law, like we all know. The national and regional chapters try as much as possible to foster scholarly collaboration and engagements, within specific regions and states, or, in furtherance of the ICONX mission, which spans all areas of public law, like we all know. So the Nigerian chapter exists, for ICONX, just like other chapters in every region of the world. And like Professor Zubike introduced earlier, Professor Wahab Ebeole, the Silky Prof that just spoke some minutes ago, is the chairperson of ICONX, while Professor Zubike is the scribe for the Nigerian chapter of ICONX. Myself, I am the co-chairperson. And so we welcome expressions of interest, those who might want to join us. Really is an exciting association of scholars where we get to exchange ideas about matters that are really of interest, both nationally and internationally. And you can register online to join ICONX. You can find a link on our website, the ICONX website, which is www.iconex.society.org. Therein are embedded the various chapters and the link where one can join any of the chapters. So with this few introductory part of the mission and objectives of ICONX, I welcome everyone once again, and I hope and believe that we are going to have a wonderful time this evening. Thank you so much.
Thank you. So today we have, like I already said, very interesting collection of speakers that will be speaking to us, and I wouldn't want to keep us for so long. I want to welcome Mr. Amar Ahmed. Mr. Amar Ahmed, it's a great teacher. He's the founder of NCA Online Tutors, a barrister and solicitor of the Alberta Bar in Canada. He will be speaking to us in about 15 minutes, and then we can go on to hear from Honorable Justice Fidelis Anyuku, Aki Akintayo, and the rest of our people. Thank you, Amar. You may have go on.
Can anyone hear me? All the participants?
Yes,
You
we
can
Yes, we
hear
can
can.
you.
hear you. Okay. First of all, I would like to thank ICON as Nigeria chapter, the organizers of this conference, for inviting me as one of the speakers. I would also like to thank all the guest speakers for sparing their valuable time and sharing their insight on the topic of constitutional law development in a globalizing era. I'm especially thankful to Dr. Akinola, Honorable Justice Fidelis, Professor Margarita, Professor Noman, Professor Negozi, Dr. Negozi, Professor Azubik, and Professor Wahab. So thank you everyone, and thank you to all the participants. I will not take much time and just going to share my insight on this topic. So in this presentation, I will explore three key aspects of the constitutional law development in a globalizing era. So first of all, I would highlight the benefits of having a constitution. All of you are familiar with some of the benefits. Then secondly, I will talk about what is constitutional globalization, and then what is the impact of constitutional globalization. And then lastly, what is the role of lawyers in constitutional globalization? So let's first have a quick look at a few benefits of having a constitution. As all of you know, constitution of a state forms the essential legal framework that outlines the organization, functions, and powers of the government while safeguarding the rights and freedoms of individuals. So, constitution establishes rule of law, which means everyone is equal before and under the law. Constitution also defines government structures and powers, which means that it outlines the roles and responsibilities of the executive, legislature, and judiciary. Constitution also protects fundamental rights and freedom. In Canada, we have Constitution Act of 1982, which guarantees to everyone freedom of religion, freedom of expression, right to equality, right to life, liberty, and security. So these are a few fundamental rights which have been given in the Constitution Act of 1982 of Canada. Then constitution promotes stability and order. Then constitution ensures democratic governance. And lastly, I could say that constitution provides a mechanism for amendments and reforms. In Canada, there are 5 different ways to amend the Constitution Act. Now, let's move to the another aspect. What is constitutional globalization? Constitutional globalization pertains to the growing impact of global legal principles international human rights standards, and foreign constitutional ideas on national constitutions and legal framework. So there are few key aspects of constitutional globalization. Number one, it has influence of international law on national constitutions. Many countries incorporate international treaties like the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Secondly, the second impact of constitutional globalization is judicial cross fertilization. Judicial cross-fertilization means that courts in different countries, they refer to foreign judicial decisions in their rulings. For example, Indian Supreme Court has given reference to United States of America's decision and UK case laws in their rulings. The third aspect of constitutional globalization is spread of democratic and human rights now. Many modern countries emphasize democracy, rule of law, and human rights, aligning with international standards. Another aspect of constitutional globalization is globalization of constitutional reforms. Countries, while drafting the new constitution, they often study and borrow from existing one. For example, the Kenyan constitution of 2010 was inspired by the South Africa's post-apartheid constitution and other global models. Another aspect of constitutional globalization is role of international organization and courts. So bodies like the United Nations, the International Court of Justice, and the International Criminal Court influence national constitutions by setting legal standards. And the last aspect of constitutional globalization is global governance and constitutional adaptation. So national constitutions evolve to accommodate global economic and environmental issues such as climate change and digital privacy. So these are the few aspects of constitutional globalization. But at the same time, now it has a few challenges. What are the challenges? The constitutional globalization may conflict with national sovereignty and may conflict with local traditions. Constitutional globalization also, some nations resist foreign legal influence due to cultural and political differences. Another challenge for constitutional globalization is that there's global legal standards may not always fit a country's unique historical and social context. And lastly, there is a challenge of constitutional globalization that we may have knowledge limitation of the legal community. So these are, in my view, a few challenges for constitutional globalization. Now, what is the impact of globalization? What is the impact of constitutional globalization? The impact is that there is rule of law. There is rule of law. In the United States, the US Constitution enshrines, I'm giving you the example of United States. The United States Constitution enshrines the principle of the rule of law in Article 6, stating that Constitution is the supreme law of the land. And then the second impact of constitutional globalization is government structures and powers in Canada. The Constitution Act of 1867, formerly known as British North America Act, defines the division of power between federal and provincial governments. So in Canada, the constitution legislation is done at two levels. One is by the federal government under section 91 of the Constitution Act of 1867. And then there is a section 92 of the Constitution Act of 1867, which gives the powers to the provincial government. There are 10 provinces in Canada, so they can make legislations of their own. For example, Alberta province, British Columbia province, Ontario province. So this is the distribution. Then there is another impact of constitutional globalization, that is fundamental rights and freedom. So the example is South Africa. The South African Constitution of 1996 is known for its strong protection of human rights, particularly in response to apartheid. Then another impact of constitutional globalization is stability and order. And the example is of Germany. The German Basic Law was designed after World War II to prevent dictatorship and ensures democratic governance. It establishes strong institutions and independent judiciary and checks against authoritarianism. The last impact I could see, I have given the example of India. So democratic governance. The Indian Constitution of 1950 establishes the world's largest democracy. It, it provides the regular elections, an independent election commission, and fundamental rights that empower citizens to participate in governance. So these are briefly the impact of constitutional globalization. Now we move to the next role. What is your role? Role of lawyers in constitutional globalization. What is my role of lawyers from different countries? Briefly, I would just explain that the role of the lawyer is they advocate for human rights. So lawyers promote the adoption of international human rights standards in national constitution. They challenge the law that violate global human rights and principles. Second is, what is the second role of lawyer in constitutional globalization? So they influence judicial decisions through comparative law. Lawyers cite foreign judicial precedents to strengthen constitutional arguments. Courts increasingly give reference to legal principles from other countries or international courts. For example, the Indian Supreme Court often gives reference to US and UK. What is another role of the lawyers in constitutional globalization? That is with reference to drafting and amending constitution. Lawyers help draft constitution that reflect international best practices in democracy, governance, and human rights. Another role of the lawyer is representing clients in international and regional courts. Lawyers represent individuals, organizations, and governments in courts like International Court of Justice, International Criminal Court, and Africa's Court on Human Rights and People's Rights. So these are a few roles of the lawyers in constitutional globalization. Then lawyers also advise governments on international treaties and compliance. Lawyers guide the governments in ratifying and implementing international treaties. Lawyers ensure that new laws comply with international agreements, such as United Nations treaties. And the last role I could see for the lawyers in the constitutional globalization is lawyers promote legal education and awareness. Lawyers educate the citizens, the lawmakers, the judges about constitutional globalization. They organize seminars, workshops, publication, the one you are attending right now. So all the credit goes to different lawyers and organizers of this conference, the law professionals, the educationists that they promote awareness of constitutional globalization. Now, are the benefits of globalization knowledge for the Nigerians law professionals. So this is with reference to a particular reference to with Nigerian law professionals. However, it is also applicable to other law professionals from other countries. What is the benefit of having a globalization knowledge of the constitutional globalization? Number one, it has expanded career opportunities. Lawyers with global legal knowledge can work with international law firms, multinational corporations, and global organizations. Opportunities in UK, US, Canada, and the Middle East are increasing for lawyers from all over the world and lawyers from Nigeria, India, or from any country. So they are increasing. These are expanded career opportunities if you have the knowledge of constitutional globalization. The second benefit I could see, the benefit of globalization knowledge for Nigerian lawyers and for all other law professionals is that they have the ability to handle cross-border cases. Understanding globalization helps Nigerian lawyers and all the lawyers. They can advise clients on international transactions, on arbitration, and cross-border disputes. So, essentials for the lawyer dealing with corporate law, immigration law, intellectual property rights. So, these they have, if they have the ability to handle cross-border cases, this is a good benefit. Another benefit I could see for the globalization, constitutional globalization, having the knowledge of that is the benefit stronger legal research and advocacy skill. Lawyers with knowledge of globalization can use international case law and treaties and foreign legal precedents to strengthen their arguments in the courts. They can leverage comparative law to advocate for constitutional reforms and human rights protection. Another benefit I could see is the competitive edge in international arbitration and mediation. Global trade has led to increased dispute resolution through arbitration, requiring lawyers skilled in international arbitration laws. Knowledge of globalization allows lawyers from all over the world to participate in cases of global institutions like International Court of Arbitration, London Court of International Arbitration, Permanent Court of Arbitration. So these are the benefits of having a globalization knowledge on different aspects. Then, lastly, there are opportunities in the human rights and international law. Lawyers with globalization knowledge can work in international human rights, humanitarian law, and refugee law. They can represent clients in organization, International Criminal Court, African Court on Human and People Rights, United Nations legal bodies. So these are the few benefits I can think of. There may be many more, but these are the few benefits which lawyers can have if they have the knowledge of constitutional globalization. And this is for everyone. I thank you, all the participants. I thank you, all the guest speakers, for sparing their time. Thank you so much. This is my name, and this is the name of my organizations. I'm a barrister and solicitor in the province of Alberta, Canada. And anyone wants to contact me, they are welcome to contact me through my website. Thank you, the moderators and the guest speakers and the participants.
Thank you, Mr. Mar. Professor Ngozi, are you there?
Oh, yes, I'm here. Okay, thank you so much for engaging us. It's quite an interesting presentation, and I believe we'll have one or two comments from the participants. But before that, I would like to tell us to hold our pace. Probably after the presentations, then you could make your comments and your observations known. Let me welcome the next speaker, Honorable Justice Fidelis Anyuku, to have the floor. Is my Lord Justice still with us?
Yes, I am here. And good evening, everybody.
You're welcome.
Thank you to the organizers of this event. I hope I am loud enough. Can you hear me?
Yes, we can hear you. Can hear you.
Okay. Thank you, the last speaker. I came here to learn actually, and I must say that I picked one or two very important things from the presentation of the last speaker. My own is just to discuss, and my intervention will be limited to our practical experience in the Nigerian context. I will speak on the impact of globalization on the constitutional law development. I'll begin by saying that the effect of globalization that no state or country these days lives in isolation. Whatever happens in a country is no longer viewed only through the prism of the norms of that country. Question that really comes to mind is this conform to the international best practices? These days, there is a greater interconnectivity and cooperation among nations. This interconnectivity influence domestic constitutional interpretations. We find the courts factoring in give an instance. The court customary practice of the laws, to say to some extent, still is that women do not inherit their father's property. The thinking is that women get married, should get married, and leave their father's house, husband's houses. However, present day reality, every woman must not get married, and every woman must not stay in marriage against all odds. The prevalent global practice is that women are not second to men, and they are not appendages to men. Women have their own identity and the right to own property. The Constitution of Nigeria, recognizing this global trend, enshrined in Section 42 of the Constitution the right to freedom from discrimination based on gender. So, following this, when disputes relating to the exclusion of women from inheritance under the Constitution get to the court will recognize that indeed such exclusion is the practice of the society. But the court will still insist that such practice should be jettisoned while gender-based equality is embraced in sync with the international, with the global trend. In the wake of these decisions of the court, which say that women should, line with global flag practice, inherit property, the court, the people will now see that there is the place of the girl child in the society is promoted. People now celebrate giving birth to a female child, unlike what obtained in the past when the girl child was dead. However, we should apply caution and strike a balance between global trends and national sovereignty, national identity, and what the last speaker called unique historical and social context. I must tell you that following this trend of giving the women equal inheritance rights, some women have taken to bringing some application before the court to take over entirely rule of men in the traditional society. This may happen someday, but the balance they are striking is that laws, even customary law, evolves with time. It's not something rushed. It leaves trends and trails. You don't jump from point A to point C. So I would say that I advise that we make haste slowly. And I will also talk about another aspect of the impact of globalization and the need for us to strike a balance. We always ask, what works for us as a people? What as we embrace globalization, we must always look for our uniqueness, find homegrown solution to our everyday issues. Let me relate this to our national experience in elections and election litigations. You see, like after the last presidential election, we are calling that our laws should be amended so that provisions will be made that election litigations should not last more than 30 days. And I agree that we should strive towards that because that is one of the things almost all the civilized countries in line with the trend. We should also key into that. However, it should not be a function of legislation alone, saying let's amend the constitution, let's by the electoral laws make provisions for fast track litigation. The process should be holistic, starting the conduct of the election itself before it gets to litigation. We will ask, how are these elections conducted? How are data collected and preserved? What is the orientation and disposition of Nigerians towards credible and transparent election? Are we ready for that? Or should we, just because we wish to be like the global world, make provisions that at the end of the day will not get to the root of justice? You see, litigation in some of these countries where the proceedings during election petitions are fast-tracked are basically what they apply there are basically questions of law. The facts are almost always non-disputed because they have basic way getting these facts. The facts are trusted. The process is trusted. The only thing you do is that where there is disagreement, you collect all the documentary evidence and place before the court so that the court will just apply applicable law to the factual situation. But in this country, our uniqueness, and that's the advice we must always give ourselves. What contains in this country? We just submit documentary evidence when the common man in the country does not trust the facts. And even everybody will agree that the process of getting these facts are still not trusted. Based on that, every question of fact is tested so that at the end of the day, we will not make haste side of justice. People call witnesses to come and testify in addition to the documentary evidence. All these are the factors that slow down litigation in Nigeria. And we will not say because we want to be like the Americans when they submit litigation today, in the next 1 week or less than that, results are out and then the court will make declarations. Say, okay, let us close over facts because this country we are not yet ready. The lawyers are not ready. Players in the election are not ready. The ordinary man in the street are not ready. And even the courts are not ready. So I will repeat that we need to strike a balance. Yes, we need to be like a global war, but our unique historical and social context must also be put in place. When we advocate for globalization, it should be holistic. We shouldn't leave it only on legislation, law. We should also consider social factor in whatever we do so that that balance will be achieved. And having said this, I must thank everybody that has attended this webinar, starting from the organizers, the keynote speakers, discussants, moderators, and the revered Vice Chancellor of the University of Illinois, Professor Senior Advocate. Okay. Thank you, everybody. Thank you.
Thank you, Milord. You would agree with me that Milord has really raised some very interesting points that we are going to talk about at the end. And let me quickly call on Professor Margarita Salvadore. Professor Salvadore is a professor of international law at the University of Torino in Italy. Professor Margarita, please, you have the floor.
Thank you very much. I'm pleased. I want to thank, I'm honored to participate in this very insightful meeting. Thank you all the organizer. Thank you for having me. And I would like to contribute with a European perspective to the constitutional law development. I would like to focus my perspective on the articulation between European Convention on Human Rights and European Union law and national constitutional courts. My first and foremost consideration is that in Europe, national courts are not isolated. Rights and courts have been the cornerstone of the new constitutionalism born from the ashes of totalism that has dominated the scene for over 50 years. National judges and constitutional courts serve as irreparable frontline safeguards. And yet, by now they know, and most importantly, citizens know, that in Europe we can count on the other additional supports and backup. The current situation makes even clear the added value of belonging to a broader family that is united by bonds of common value, supported by a network of committed political and juridical actors, and yet allows room for individual personalities in a pluralistic nature and is pluralistic in nature. Today, we can only prize the richness and even the complexity of the European judicial system for protection of fundamental rights, democracy, and rule of law, all core and basic values across the continent. As the European Court gained greater importance, national constitutional courts have lost their position of final authority, and this was a major change. Within the European context, the same case can be brought before one of the two European courts especially to the European Court of Human Rights, even after a national constitutional court has given its ruling. In fact, there have been many cases decided in Strasbourg where an individual complaint has challenged a previous decision by a national constitutional court. And all in all, the possibilities of further review by supranational courts on the same case ultimately enhance the quality of domestic decision. Conflict and disagreement between national and supranational courts arise just like in any group of friends and family. Occasionally, they may hold a divergent view on the same case, follow different interpretation of the same right, and provide different balance between competing principles. Over time, however, national courts, including constitutional courts, have come to realize that their role and power are not diminished by the presence of other human rights adjudicators, especially at the supranational level. On the contrary, they mutually support and strengthen each other's. The European system entrusts national authority within the primary responsibility of enforcing fundamental rights, including those protected by the European Convention, the EU Treaty, and the Charter of Fundamental Rights of the European Union. Among these national actors, national constitutional courts play a pivotal, not secondary role. They accomplish their mission to enforce fundamental rights as protected in Europe in two different ways. The first and most common way is by means of interpretation. They consider the rights protected by the European Convention as interpreted by the Strasbourg Court not to be part of the national constitutional law, or, if you want, part of the common European bloc of constitutionality. Therefore, national constitutional court play a dual role. In one side, they implement the European Convention of Human Rights and European law, contributing to the dissemination of the European case law within the member states. In a way, they act as European courts at the local level. In the other side, the European law on fundamental rights provide national constitutional courts with additional instruments, tools, and arguments for reviewing national legislation. National constitutional courts are empowered rather than undetermined by the very presence of other counterparts in Europe rowing in the same direction. The same is true and can be repeated in the other way around, that strong domestic courts are essential for the proper functioning of the European system. It is a win-win situation. In conclusion, I would like to once again highlight that over the past decade, and so the different judicial with the non-judicial institution across Europe have shown an extraordinary ability to close rank and work together for the common goal of protecting the rule of European constitutional law, made up of common constitutional principle and tradition, whereby any power is free to interpret the national identity, but at the same time is bound to abide by the higher law. All in all, if we broaden our perspective and look to other countries, we can humbly say that in this turbulent area, any citizen should feel safer and more secure within our European complex, multi-layered legal system than in single isolated country. Thank you very much for your attention, and thanks again for having me.
Yeah, thank you, Professor Margarita, for that enlightenment, from the European context. We'll get back to you at the right time. But let me quickly invite Professor Newman to make his presentation. Thank you.
May I confirm with you, can you hear me?
Yes,
good.
I can.
Great. Thank you. Thank you. First of all, I would like to express my sincere gratitude to Professor Azubike, who invited me to share my thoughts on this very important topic, especially in African context. Very recently, security was withdrawn from the Kenyan Chief Justice. The statement of Trump about Zelensky as a dictator without knowing that there's an electoral law, constitutional law that prevents him to, hold elections during the martial law. All these, these recent developments actually get back to, one question: what is our understanding of Constitution, and from where we draw the inspiration? Should we look at the developed countries like the US, the UK, Germany, Italy, France, New Zealand, Australia for our understanding of the Constitution? Or there are other understandings of Constitution. There are different kinds of Constitution, different contexts in which constitutions emerge and then they change. And I think here, having this said, we need to be very careful about our understanding of Constitution, especially being a legal scholar, when we are too much focused on laws, words, provisions, sections. I personally, and I think that's what I've been advocating and writing about in my articles, in my lectures, that the Constitution and the words, they are just dead letters. They do not do anything when some, group of judges who are humans, who do not descend from sky, they are given birth and raised in a special environment, social context. They internalize some ideas. They, when interpret and apply the law, then it acquires some meaning and it acquires some function. Without that, that's just just another book which you can keep your cupboard and be very happy about the titles and provisions, and we can read it, but we cannot see the application of that thing without the interpretation of judges. Now, before I draw some shed some light on the different perspectives on the Constitution and the which can help us understand the changing constitutions in the global era. I think it's important to emphasize that there are different backgrounds from which I am sharing these thoughts. The first one is, as I said, I teach in Leicester Law School, University of Leicester. I teach EU law, Canadian constitutional law, constitutional administrative law. In the UK, Islamic law and analyzing law. So there are different perspectives, and so I can share different perspectives when it comes to the Islamic law. There's no constitution at all, and a very good example of written example and unwritten example is in Saudi Arabia and Afghanistan, respectively. But then there's another position background from which I'm sharing these thoughts as the founder and the chief convener of the Global South Network, and having organized around 13 guest lectures of the Supreme Court judges from different countries, including but not limited to the UK Supreme Court, Mauritius, Kenya, Nigeria, Greece, Turkey, so on and so forth, and all details are there on the Global South Network website. So based on my observation and based on these guest lectures and dialogues with Supreme Court judges across the world, having taught these different constitutions, my thoughts on the constitutions is that there are three approaches to the Constitution. One approach, which we are focusing right now, that is the legal scholars approach, that is the lawyers approach, that is the judges approach. Look at the Constitution, what the Constitution says, and then let's follow that thing. But then there's another one, political scientists. Political scientists say that constitutions are created, enacted, introduced because people who want to introduce that constitution, they want to achieve some interest. They are strategic actors. They do not create that constitution in vacuum. So one of the main functions of the constitution is to achieve political interest. Now, I would like to give a very good example from Canadian context. I think it's very important to understand we all talk about Charter of Rights 1982, Constitution Act 1982, and the chief architect of that constitution was Pierre Elliott Trudeau. Now, Pierre Elliott Trudeau, this Trudeau Senior, was a law professor, by the way, and he wrote the book himself, about the French nationalism, in which he says there's no problem with the Canadian Constitution. On page 197, by the way, and published in 1968. No problem with the Canadian Constitution. Constitution Act 1867 is the perfect document. We don't need to have charter rights. There's no, it's free of American style frills, and the Charter of Rights are not required in the Canadian context. But the same Trudeau, in 1980s, start advocating we need charter rights, start negotiating with different provincial premiers, struggling a lot. The Quebec premier was the main challenge to him, and he couldn't achieve his agreement over the constitution, the different drafts of the Constitution Act 1982. Conferences 1980, 1979, all those negotiations are example. Now, the question is, what changed his mind? That's the main question. Yes, we can see that Charter of Rights, everything, the sections are there, but what was there to achieve? The political interest they wanted to achieve was the Quebec wanted to secede, and the main challenge for them was how to calm them down, how to divide them, how to address those concerns which they are raising. One of the main concern was the nationalization of hydroelectric powers, which they raised in back 1960s, and then start highlighting in 1970s onward. So how to absorb that thing, and I think they became successful when they introduced the Charter of Rights, and they said that it's the charter revolution. We have got the rights revolution, and from 1990 onward, the whole resistance that slowed down is because they ensured the guarantees. The federal government was kind of saying that, look, we introduced that thing. Now, what I'm trying to say is that there is always a political interest to achieve. Constitutions, I am sorry to say, it's not only about rule of law. It is one of the factors, apparently, it is rule of law. Every constitution says, even the Saudi constitution, basic law of the Saudi constitution, there, if you see, they also say, and every Kenyan, Nigerian constitution, Argentinian, Brazilian constitution, you see, there will be some mention of judicial independence, rule of law. They love to say these things. But is it happening or not? That in order to understand that, we need to understand the concept of rule by law. And when it comes to rule by law, constitution is a very good instrument to achieve that thing. What is rule by law? Rule by law means to preserve the hegemonic control of majorities, majority community, majority group in any society or the state institutions. For example, Punjabis in Pakistan, Sinhalese in Sri Lanka, Ashkenazi Jews in Israel, and Nigerian context, I would not like to say, but well, you can understand there are different tribal ethnic groups, which group is right now in the power and what are their control over the Nigerian constitution. That I leave it to your judgment. Now, the second perspective, the third one is the sociological perspective, sociological approach to constitution. Now, what sociologists say? Sociologists say that constitution is not created only in the legal context, common law, civil law tradition, not in a political division like the conflicts between the opposition and those who are in power, but it's also about the class conflict, the upper class, the middle class, and the working class. And I think it's very good, it provides a very good understanding of at least the UK constitution, where there's no written constitution, no codified constitution. There is a written constitution, but not codified constitution. And different constitutional documents were enacted in context of the conflict between the middle class and the rest of the society, which expressed that conflict was expressed in different historical moments. One of which was Constitution Reform Act 2005. At the Brexit itself was a constitutional moment. And those moments, if you see 51% versus 49%, that itself shows that there was a sociological conflict in the context of which different constitutional documents were enacted. Now, when I say these were the different, these perspectives only provide different understanding. What are the challenges? And I think that's, two challenges by our honorable guest speaker, Amar Ahmed, were very important. We need to be very skeptic towards the foreign judgments, foreign legal traditions, and the legal documents. We need to apply our, see our own context. When I say our, I mean to say the global South, developing countries, authoritarian states, hybrid states, whatever name you want to give to these countries, which unfortunately all these names were given to us by the global North scholars. We never pick up these things. We were put in different categories as guinea pigs and labeled as under these different headings. But whatever name you want to give, I mean to say by our, I mean to say this. Our means these kind of countries, their traditions. They need to be very skeptic. Is because the whole assumption, the whole legal system of the global North, Canada, Australia, New Zealand, US, UK, they based on these assumptions, like the assumption that whole world has to somehow follow one way of one way of spending the life, one worldview, global worldview, and that global worldview is civilized, and that global worldview is the best way of achieving the law and order and the rule of law in a society. There's a underlying assumption, and that assumption you can clearly see in many judgments as well, especially with regard to the human rights judgment, especially those judgments where there was a difference of opinion between the judges in the UK and the European Court of Human Rights. So you can see that assumption, and that assumption do not apply to our context, to be honest, is because there is no such thing as civilized world or uncivilized world. There is all the things which exist is the poor countries, economically poor countries, unstable democracies, and stable democracies. Every culture has its own understanding of civilization, has its own understanding of traditions, which shape the context in which constitutions are enacted by the elected people, by the elected representative of the same society. So that's why this challenge is very important. I'm very glad that Amar Ahmed mentioned that thing. And I think in this regard, Amar Ahmed's contribution through the NCA is remarkable. I think the most of the beneficiaries of his network are the people from the global South. And I'm very glad that in a Canadian context where the law schools and other they are offering such an expensive, most exclusive services to people from the global South, especially those who have an accent, a strong accent, non-English accent, who are looked, I mean, in my opinion, pardon if you can agree, you can disagree with me, who are looked down upon in the global world. Services are given to them, they are benefiting, and many people passed NCAs, they managed to immigrate. I think that's a huge contribution to the global South in that regard. Now, what's the way forward? What are the solutions? And I think that's very important to understand. When I say all these, the purpose of saying this was not to just bash, criticize the global North. Everyone from the global North is wrong, or no. I think that's not my purpose. That's not my objective. You will be completely wrong if you looked at me as I am somehow anti-West or very critical of. I think we need to understand there is a need for bridging gap, sociological, ideological, legal, political, religious, bridging those gap between the global North and the global South people. We need to create forums, that are led by people, societies, not states, where we can exchange knowledge and share good practices independently of the state agenda or the state's institutions agenda. And one of which is right now, we are utilizing, led by Azubike, and the other one you may have a look later on at the Global South Network website. I think we need to have those forums, and these forums are very important to understand each other and to draw our attention towards a very irrefutable, unignorable fact, and that fact is cultures, legal traditions, constitutions could be different, but all of them are equal and important. Specifically saying, I mean to say, Nigerian constitution is as important as a Canadian constitution, and probably more important and more interesting than the Canadian and the UK one, where there's a linear, there's the developments are very linear. There's no up and down. They do not offer very interesting stories. When it comes to the Kenyan, Nigerian, Pakistanis, Indian, and the Libyan, Iraqis, Israelis, it offers you interesting stories because they have interesting new theories to tell you. Unfortunately, the global academia and the legal scholars community, they are shaped and structured in a way where it is the correct way of learning is anything you learn from the global North is correct, but anything you're learning from global South, that you need to be filtered by someone who is there in the global North. That's unfortunate, but I think that we can definitely, we can definitely question it. We can definitely revise it by continuing these kind of dialogues and the knowledge exchange activities. In the end, what I'm going to do is, if with the prior permission of our honorable guest speaker and the organizer, allow me to share these links or anything. These links give you the details of the activities we organize. Anyone who is interested in that can, later on follow up, can have a follow-up discussion with us. Thank you very much.
Thank you, Numan. Yeah, you're welcome to share the links. Amari, you're also welcome to share your links. It's part of the globalizing effect and sharing knowledge and populating knowledge that we are working on. Several, you will agree with me, we have very high points that we are going to discuss. Let me call on our final discussant for the evening, who also doubles as the co-financial secretary of ICON-S Nigeria, Associate Professor Akiola Akintayo from the University of Lagos. Dr. Akiola, please, you have the floor.
Okay. Also, can you hear me? Can you hear me?
Yes, we can. Yes, we can.
All right, great. Okay, so thank you very much, Professor Asibike, and Ngozi. Allow me to stand on the existing protocol. Also, thank all the contributors that have already spoken on this very, very important issue. For me, I think I'll just start where Professor Newman just brought to mind. I want to agree with him that we need to take a critical approach, critical perspectives into globalizing constitution. Having said that, we are not saying that everything from the global north is perfect and that everything from the global south is not good. But I do believe that no nation, no country is an island in itself, and we both the north and the south, can learn a thing or two from each other as appropriate and as time permits and higher. So for me, I think I want to domesticate discussion. I want to kind of Africanize the discussion and ask the question: what are those factors that have been hindering the globalizing constitution or constitutionalism in Africa, with a specific reference to Nigeria? And the first point I want to make is the issue of a conservative judiciary. We all want to agree with me that for the constitution to be globalized, for norms and best practices to be globalized, the importance and the role of the judiciary cannot be overemphasized. They have a very critical role to play in that globalizing nation. Not only that, they also have a very important role to play in globalizing democracy as well. For instance, in Nigeria, in one particular case, Paradigm Initiative versus Attorney General of Information, just to illustrate the point I'm trying to make about the importance and place of the judiciary in this globalizing initiative. In that particular case, the challenge was brought against Section 21 of our Cybercrime Act, which prohibits cyberbullying and said that you will share the news that, to your knowledge, is false, to cause annoyance, to cause insults, etc., etc., using those very big words that will be guilty of an offense. So the matter was taken to court, and the claimant in that particular case cited before the Nigerian Court of Appeal jurisprudence from India, from Kenya, where similar words in their own statute have been struck down as unconstitutional. But the Nigerian Court of Appeal refused to take that reference. They refused to follow those decisions, saying that the only time, first of all, that foreign decisions are not binding in Nigeria or Nigeria court, that is very correct, and that the only time that they will be willing to make reference or apply foreign decisions will be when there's no provision in Nigeria, no provision under Nigerian law that is having anything to do that is dealing with that particular subject matter. And they refer to Section 3612, which says that if an offense which is created by statute is one of the exceptions to criminal provision in Nigeria that will make it valid. So, what am I trying to say? In that particular case, the court rejected decisions of foreign courts that were cited before them. Those decisions that ideally should amount to best practice, they rejected them and sanctioned that provision of Section 21 of the Cybercrime Act. So, the judiciary has a very important role to play in globalizing constitution. If the judiciary is not proactive, it is not progressive, there's going to be a problem. Another factor that I've identified here is, of course, what I call retrogressing human rights and democracy. For decades now, for years back now, studies have shown that both human rights and democracy are receding. They are retrogressing, and there are reports and studies and samples and experiences from all over the world to show that both democracy and human rights are retrogressing. In a world where human rights and democracy are retrogressing, what scope is there for to globalize constitutions, to globalize best practices? Are we not going to be globalizing retrogression and recession of human rights and democracy? That is a rhetorical question. The third point that I identified here, the third factor, is growing isolation and xenophobia across the world. In the US, South Africa, Italy, and other parts of Europe, all saying, no, we want to be left alone. We don't want immigrants in our country. We don't want strangers. We don't want our culture to be contaminated. We want to remain pure. In that kind of a world, what then is the hope for to globalize the ideals, the good norms inherent in the globalizing constitution? Another point here that I've also identified is the relatively weak civil society, the relatively weak mass mobilization mechanisms. For there to be a functioning democracy, a working human rights regime and mechanism, the citizens need to be active. The civil society needs to be up and doing. Because the truth of the matter is that nobody, no powerful person will easily use power. The government will not easily use power. Those in public offices will not easily do what is right. You need the pressure from civil society, you need the pressure from the public in order for that to happen. What am I trying to say? There must be an active civil society that is able and willing to push the frontiers of change, for there to be good governance, for there to be accountability, for there to be implementation of best practices. Where that is lacking, then there will be very little hope for the globalization constitution. I think they are doing something. Another very important point that I want to mention here also is the issue of state capture of organs of government, arms of government, the state capture of critical arms of government, especially in places where a presidential executive is being practiced. For instance, like the case in Nigeria, we see across many countries in Africa where the executive is so powerful and overbearing, and that they have been able to capture and immobilize the other organs of government, like the legislature, like the executive. They have kind of subsumed them into governance, subsumed them into executive governance. And if there's no separation of function and powers as mandated by the principle of separation of power and rule of law, there cannot be checks and balances. The constitution itself cannot work, it cannot function optimally, where the organs of arms of government are supposed to act as checks and balances where they are missing. That is what appears to have happened in many countries now. Some legislature across African countries are rubber stamp legislatures to do the bidding of the executive. The judiciary also have been captured. They are not bold or effective enough to say no to other arms of government, to say no to the executive, to say no to misbehaving political office holders. And their main function under the Constitution is to say no when it is appropriate. It is to say no when it is important. Where the judiciary cannot say no, then where then will be the hope for good governance and globalizing constitution. Finally, and very importantly also, is the issue of growing substantive inequality. I mean, we have formal equality in terms of the guarantees of fundamental human rights, according to the Western concept of human rights, right to life, freedom of expression, political participation, etc., etc. But the Western concept of human rights privileges civil and political rights, while relegating economic and social and cultural rights. And these last species of rights are the ones that are most important for African masses. They are the ones that are most important for African situation. They are ones that are most important for good governance in Africa. How and why? It is only a citizen that is well-fed, that is well-educated, that is well-housed and is healthy, that is going to be able to stand against the coercive and awesome powers of the government. If you don't have the resources to engage, you cannot engage or fight or hold the government accountable. Thus, where these species of rights are denied as a matter of course, as a matter of routine, what is going to happen is that the citizen will become impoverished. They will become powerless. They will become politically excluded. And I mean, a case in point is what happens every time an election is going to take place in Nigeria. For a few naira, a few thousand naira, 2,000, 3,000 naira, which is not even up to, you know, probably 10 cents or whatever, a citizen of Nigeria will be willing to cast his or her vote just to receive that few thousand naira for that day, to vote for somebody who they know is not going to perform, who they know is not the right person for the office. But because of that money, I mean, they have been dehumanized to that extent. And that, in turn, has affected their political participation, power, and effectiveness. And of course, ultimately, it's going to affect accountability and good governance. Because what it's going to mean is that we keep recycling these politicians that we say are not, performing. But when they bring the money, the majority of the people will still take the money and vote for them. Why? Because they have been dehumanized, they have been impoverished to that level. So we need to have a rethink and change our focus, change our priority from civil and political rights, if not totally change over to economic, social, and cultural, but at least to place them at the same level, at the same pedestal, and ensure that both categories of rights are as enforceable and implementable as the other. I think I will draw the curtain there for now. Thank you very much.
Okay. Thank you so much, Dr. Kane, for those critical perspectives. Indeed, the issues raised are really mind-boggling. But then, let's see how we're able to adjust. Let me call on the chairperson of ICONX, the main brain behind the Nigerian chapter of ICONX, in the person of the Silky Prof, Professor Ebowole, to kind of summarize and these different perspectives that we've been engaged with from the various speakers, because their thoughts are really insightful, and we need to hear what the chairperson has to say before we open the floor for other persons to join. And thank you so much. I call on over to you now, Professor Bowley, SAN. Thank you.
Thank you, co-chairperson. I want to appreciate Honorable Justice Fidelis Aniku, my Lord. I appreciate Professor Salvadori, Professor Rayat. Nauman, thank you so very much for taking time to be part of this conversation. And of course, Dr. Akintayo. Let me say that the various perspectives have been extremely insightful, and there is no gainsaying the fact that the issues has been raised has also touched on a number of areas with respect to constitutional law development in the globalizing era. For me, the most important issue that had been the chord that the discussions had hit in me is the issue of the centrality and fundamentality of the judiciary in the democratic space. I listened to Rayat, and it is obvious to me that the contributions had emphasized the importance of the judex in the process. And of course, I also share the perspective of the main speaker, Hamad, from Canada. One thing that also struck me in his contribution is the fact that he had provided contemporary experiences on the issue we are currently discussing. On the whole, I believe in reiterating the point I made earlier, we should not allow this discussion to end here. We should also try and see how we can weave a project around this for the purpose of more scholarly and insightful discussions. Thank you so very much.
Thank you, Professor Wahab. And definitely, I can tell the participants that IconX will be looking at how to follow up on these conversations. We'll be ending this meeting in about 15 minutes, 20 minutes tops, so that our Muslim faithfuls can proceed to break their fast and have their prayers. So, but we want to quickly have questions. If you have questions, can you raise your hands, or you want to drop them in the chat so that we can also read them out? Very, very interesting perspective. As I'm speaking, I'm expecting the hands to be coming up. Justice Anyuku talked about national identity and uniqueness, striking balance, and I saw in the chat box he was like that Newman was giving flesh to some of his ideas. And then Akin also talked about the question of xenophobia, and what I think I just pulled down together to think about deglobalization. You know, how do we want to, if our identity is not progressive, for how long do we stick to our perspectives? And then Professor Zavere said something which I also find very interesting, that the stronger national institutions become, then the stronger the sub-regional and regional institutions can be. So these are questions that we need to look at. So if you have questions, can we have by show of hands so that we can quickly take questions and push towards the end? Yes, Islamia Kolawole, please go ahead.
Good evening, Professor. How are you doing, sir?
Very well.
Good evening, ladies and gentlemen. My name is Islamia Kolawole. I'm a graduate of University of Ilorin. Not too long ago, I was in Professor Azubike's Law and Social Change class and Professor Bewole's Jurisprudence class. And I must say that almost everything we have discussed this evening so far, our discussions on both classes are focused on these jamming questions. And I must especially thank the speakers for taking the time to have such an engaging discussion. It's been really insightful. Now, my question, it's not a question per se, but well, I guess we can call it a question. For example, I would like to make a comment on Professor Newman's presentation. And I would like to say that I very much agree with his position that we need to be very critical of what we, quote and unquote, learn from the global south and seek to implement in the global north. Because we need to consider the fact that the cultural context and the socioeconomic realities differ considerably. That brings me to Professor Aman Ahmad's presentation. Now, my question is kind of like, I do agree that Nigerian law professionals have a lot to gain from constitutional globalization. But we need to also consider the fact that we should start looking at what Nigerians seek to contribute, not just gain. What do we seek to contribute to constitutional globalization and by extension, international law generally? Because there have been several scholarly opinions on the fact that international law as we have it now does not reflect the realities of in context, African state. So it's more like before, to my own opinion, before we can have a true international legal system, it must consider the peculiarities of civilizations that is not non-Western civilization, basically. As Africans, how do we make contributions to international law in a way that will reflect our cultural consciousness? We should be looking at not just, to my own opinion, not just what we seek to gain. Of course, we're going to gain a lot, but what do we intend to contribute to the discussion on constitutional globalization and international law generally? And Professor Sabado, it's nice to meet you again. I was in your jurisprudence class when you came to University of Ilorin as a visiting professor. And yes, I very much appreciate your perspective and the fact that you brought the European human rights discussion to the table. And as an aspiring African scholar, I must say that the African Charter on Human and People's Rights, which is like the regional human rights instrument in Africa, it bears a lot of similarities with the European Convention on Human Rights, but to a large extent, it reflects that Africanness. Like it reflects a perspective that can be argued as African. For example, the African Charter is the first international human rights instrument to make provisions for civil and political rights, as well as socioeconomic rights, and as well group or, in other words, solidarity rights. So yes, I'm just putting that out there. But all in all, it's been a very engaging discussion. University of Ilorin has always shown initiative to ensure that students are introduced to not just domestic law, but international law. If I could remember very correctly, Professor Azubike he led a cross-cultural dialogue alongside Professor Egbewole just last year with University of Ilorin in collaboration with Robert Gordon University. And the university has been consistent in encouraging its law students that there's so much opportunities for us out there. And personally, I've taken advantage of that. And thank you for having us. It's been a very insightful section. Thank you, sirs and Mars.
Thank you, Islamia. Islamia is currently studying for her master's at um, in Turkey. Numan, she got a scholarship and she's in Turkey right now. So it's part of the globalizing, and that is why we organize this. And we also bring our students in to engage, be part of it, and know that they have greater perspectives and greater worlds out there. So I'm sure that quite a number of them that are on the call, we also leverage on what you have dropped in the chat room and also what Aman also has to offer in giving them opportunities to express themselves. Any other questions, any other comments before we end? Alessandro, do you want to say something?
No, I just don't want to say anything, but I'm so excited to be here and to listen all professors that speak before. It's so interesting the debate. I'm in class of transitional justice with the professor, and we often talk about global north and global south, and we made a debate last week. So now I have new website on which I can read. So thank you, and have a nice evening, you all.
Thank you. In the absence of any other questions, may I revert to our speakers just in 1 minute, your final thoughts before we end the session? Just in 1 minute, in no particular order. Newman, do you want to go first?
I think it's better we start from the keynote speaker.
Okay. Yeah, Mr. Mar, are you available
Yes.
at this time?
Thank you, Professor Norman. But it is okay. All of us, I'm very happy. I'm very honored that organizers, especially Professor Norman, Margareta, Ezebek, and all the Professor Naguzi and all members, Professor Wahab, and thank you for inviting me. And I learned a lot from all the guest speakers. And we hope to continue with this kind of academic and educational sessions. Any of you has any questions relating to the accreditation process in Canada, like how to become a barrister and solicitor in Canada, please feel free to message me, call me. Professor Azubik has my information, and I have also posted in the chat box. Thank you once again for inviting me.
Thank you.
Thank you.
Milord, Justice Anuku, are you here?
Yes, I'm here.
Okay.
My last word should be to thank the organizers and also to speak out what I wrote in the comments section. If I had known, I wouldn't have spoken first, because after Professor Norman spoke, I now saw, yes, that there is actually some perspective to globalization and the way we should be looking at the constitutions that I have not really averted my mind to. And I think that should apply to everybody here. Another thing I should say is that the one of the speakers, I guess, mentioned that the laws are made by human beings, and our historical background shape what we think should be the law, and how we approach the law. So I will suggest and advocate that every lawyer, anywhere you are, especially in Nigeria, that we are still developing, that we should engage in serious continuing education so that we will have the broader knowledge of these laws we all practice, because it will help you when you present cases before the judges, and you present it in such a light like I've seen today, definitely it is persuasive. And the courts are human beings, and we have ears, we have minds, and we know when somebody is saying something good, even if we've not heard it before. It will help when we advance our knowledge of the law so that at the end of the day, the court will bring out that kind of judgment that we need to shape our society, to put us in line with the global world. Thank you, everybody.
Thank you.
Thank you.
I also would like to thank everybody, and it was very insightful the discussion. I also learned a lot of things, and thank you so much to everyone. And I just want to point it out the idea of collaboration between cards, constitutional cards, that I think the European experience give a lot of thought to think about. In which way to find collaboration between national courts, because this level of collaboration, the multi-level
on the safe use of machinery from the equipment manual.
between cards, different international cards and national cards, give a perspective very important, and you can see that from the European experience that I perfectly understand that is global north, if we use, but is an example, is a case study, very interesting to have a higher level of protection of human rights. I think that that's my last, if you want to send anyway, my last talk in this conference. And I want again to thank the organizer, and particularly Professor Azubike Onuora-Oguno, that is the main organizer this tonight. Thanks a lot.
Thank you, Numan.
Thank you very much, Azubuki, once again for conducting, organizing such an excellent activity. I think it was really insightful and very refreshing. And I always love to talk freely on your forums, other than the forums which are apparently very does educate and show that there's a freedom of speech and everything. Anyhow, my last words are simple, and they are like any PhD scholars or students from the global south, be it a Kenyan, Nigerian, Libyan, Iraqi, Indian, Pakistani, Argentinian, Mexican, Cuban, they should not be, they should not feel, should not be ashamed of writing about their constitution. They should be very clear that their constitutional developments, what is happening there, the judicial behavior, are very, very interesting. And I think it does develop all legal, political, sociological theories which currently Global North is successfully propagating, because the forum is, the all these prestigious journals and publishers and everything is dominated and owned by them. Um, but they should not stop writing. I mean, I usually come across different students. They say, "Oh, we want to compare Nigeria with UK." No, you don't need to compare Nigeria with UK. Nigeria deserves proper attention. Nigeria's constitutional story is a very, very refreshing story, very energetic story. UK one I teach, I read, it's a very dull story. One document is enacted, another document is enacted, and one is changing, another is changing, and that's it. So be always, I mean, it adds to the knowledge. You should be very confident. And in this regard, the Global South Network, which I am currently leading and I founded in March 2023, offers completely free of charge. So it is very different from all other organizations, which may, I mean, I'm not saying they are doing something wrong. They are doing very good things, but I'm saying that we do not charge you for 15 minutes presentation in conferences or attending. Anyone from the mountains of Niger Delta or Afghanistan, if they have a mobile phone and a link, access to internet, they can attend prestigious guest lectures of even the UK Supreme Court judges, the European Supreme Court judges, including Hungary and Greece. They are going to be organized in October and November. And also the weekly activities we organize from bringing people from all over the world. They can attend that, they can benefit from that. Currently, many people, including Israel, we do not discriminate. Being a Muslim, I never discriminated, be it Israel or Palestine. When it comes to the knowledge exchange, we never discriminate among different ethnicities, nationalities, age group, or ideologies. So feel free to get engaged. Azubiki is already part of that. Many from the Lauren is they are regularly attending. So if you are interested, do not hesitate to contact. Thank you very much.
Thank you, Dr. Akintayo. So may I ask, as Dr. Akintayo is speaking, please may I ask you to turn on your videos so that we can do some quick photographs. Please turn on your videos. Dr. Akintayo, please.
Yeah, thank you very much, Professor Asubike. I want to thank Embassy there as well, and the other organizers of this wonderful conference. I want to say I appreciate your inviting me. Very glad to be here. I like the rubbing of minds together. I like the sharing of ideas and perspectives from different parts of the world. I think it's been a very wonderful interaction today. I also want to stress, like Professor Onuora-Oguno just said, I think it's important for us as scholars, researchers, even as students, to take a critical approach to all the issues of developing Africa generally, to take what we call a post-colonial approach to issues of law, a critical approach to issues of governance. It will do us good, it will benefit us the more. On that note, I want to say thank you very much for this wonderful opportunity. You have a nice evening.
Thank you. Dr. Ngozi, final words from you.
Okay, not too much, just to say a huge thank you to our speakers, the guest speakers, and thank them for the insightful perspectives. You know, it has actually opened our eyes more towards the need for adopt a nuanced approach, and as well a critical approach as far as constitutional globalization and what our guest speaker, Professor Ahmad, referred to as judicial fertilization. You know, and I think that will help us better to appreciate whatever it is we're analyzing as far as context is concerned. Thank you so much, everyone, and have a wonderful night rest. From Nigeria.